Next, we have In re Pearlman, Peter Kleidman, appellant, appearing pro se.
Mr. Kleidman, do you want to make your appearance, please?
Yes, good morning, Your Honors. This is Peter Kleidman, creditor and appellant pro se.
You may proceed.
Yes, Your Honors. So this case basically has to do with 362H, whereby property can be removed from the estate when a creditor has a security interest in the property and there's no timely filing of a statement of intention. And sorry about that. Let me see. Sorry about that. Sorry. And so what happened was that that occurred in the sense that I claimed to have a security interest and there was no timely filing the statement of intention, and therefore the property was removed. And I used that as a basis to try to oppose the exemptions. And the bankruptcy court said that the removal under 362H of the property from the estate was irrelevant, that even though, without determining one way or the other whether the property was removed from the estate under 362H, Judge Kaufman said it doesn't matter, because even if it were, I still have the power to impose exemptions on that removed property. And I believe that's wrong, and I provide multiple arguments in my opening brief as to why that's not true. I don't need to review all of them. One is jurisdictional. There's case law to the effect that once property is removed from the estate, the bankruptcy court no longer has jurisdiction over that property. There's also a statutory interpretation if the property is removed from the estate, if it's removed from the estate, then you can't exempt it from the estate because it's already out of the estate. And then,
excuse me, Mr. Kleidman,
yes.
Are you arguing that because there was no statement of intention that the debtor has no longer has any rights in the property?
No, I'm not arguing that. I'm saying that the debtor still has his rights in the property. It's just no longer property of the estate, and therefore there's no basis for the bankruptcy court to impose. There's no jurisdiction for the bankruptcy court to impose an exemption. In other words, the bankruptcy court cannot exempt property which has been removed from the estate under 362H. And certainly there's no case law directly on point on that.
If the property is removed from the estate, and because I don't know that it's been determined that you have a valid security interest or a valid judgment in the property, what happens? I mean,
well, the answer as to what happens is that it's free floating out there in the world, but not part of the bankruptcy estate.
Is it free floating? Or 521 talks about nothing there affects the debtor's rights in the property. So if it's not property of the estate, debtor still has an interest in it.
Yes, what I meant is the debtor still owns it, but the bankruptcy court doesn't have any basis to impose any authority or jurisdiction or power over that property because it's not part of the estate. There's a Ninth Circuit case that I cited.
What happens to the property if it's not property of the estate?
Well, then I can. One thing is that the automatic stay doesn't apply anymore to that property. But in addition, it's just when you say what happens to it, I'm not sure I understand the question. The debtor still owns it. It's just that there's no basis for him to claim an exemption on it.
So, Mr. Kleidman, your argument that 362H applies is based on the debtor's failure to comply with requirements of Section 521, correct?
Yeah, it's the failure to file a timely statement of intention, correct?
And so the question for me is, how did you demonstrate that the debtor failed to comply with Section 521 if he never listed in the schedules a liability or a claim that is secured by personal property owed to you, since that's what the requirement of the code is?
Well, the thing is, I have a security interest I claim. Yeah.
I appreciate that, but
Right.
the way 521 says is if the debtor schedules a liability that is secured by personal property and the debtor wants to either retain, redeem, or surrender the collateral, the debtor must file a statement of intention. But in this instance, the debtor did not list your claim as a secured claim. He didn't list you as holding a security interest in personal property. So Section 521 doesn't seem to apply, does it?
Okay, so what I'd like to do, that argument I've never heard before. I'd just like to take a quick look at exactly what 521 says. Do you mind?
No, go ahead. Use your time.
I'm just looking up 521. Do you mind? I mean, the thing is, you see, is that if the debtor lists property, for example, he listed.
He could list
Anyway,
the watch. He could list all kinds of personal property.
Right. Now, if he, it doesn't say that he has to.
Well, read 521.
Well, it's very long, but the thing is that if he lists property, and let's assume that he does not list it as secured property, but let's assume it is secured property.
That's not what the statute says. It doesn't say if the debtor doesn't list the property, but it is in fact secured property, then this happens. The statute says if the debtor lists the property and it's personal property and it's subject to a lien and the debtor acknowledges that in the schedules, then he has to do certain things under 521. And one of them is file a statement of intention. But it doesn't apply in the absence of. It doesn't say that if the court makes a determination later, or it doesn't say, it says the debtor must do this when the debtor files the schedules. If the debtor schedules the property as subject, if it's personal property and it's subject to a lien, then the debtor must file a statement of intention.
Your Honor, you used a very key phrase just a couple of seconds ago, and the debtor acknowledges it. So you're saying that
that 521 is dependent upon what the debtor puts in the schedules. That's
right.
what the triggering event is. Not what you believe, not what you could prove, but what the debtor asserts at the time he files the schedules. That's what the law says.
Do you mind?
No, read it. Read it. Go ahead and read 521.
I know it's very, very long. I'm just trying to let me try to find
521A.
Yeah, even 521A. Okay, let me use my time to find that. It says. So yeah, it's 521A2, 521A2, 521A2. And I think this is the point. It's a statutory interpretation dispute that we're having. Here's what it says. If an individual debtor's schedule of assets and liabilities includes debts which are secured by property of the estate,
did he include a debt that was secured by property of the estate that was owed to you?
The answer is yes.
No, he included a debt owed to you. He did not schedule it as secured debt owed to you.
Right. So the thing is, you see, is that here's what the statute says. If he has in his schedule an asset, okay, if he schedules an asset, and that asset is secured by
That he has scheduled it as secured.
No, that the statute doesn't say that. That's our agreement. See, if you look at 521A2, which I'm looking at now, he doesn't have to schedule it as secured. He just has to schedule it as an asset. In other words, there are two independent inquiries that the court needs to do. The first inquiry, is it scheduled? And the second inquiry, independent of that, is it secured?
Okay,
and it's
let's go to the that it is secured. Okay, there's a judgment that you obtained years ago in New York, and there was a security agreement entered in New York. But now we've got iWatch and other property here in California. Some of it's after acquired. There's a California statute that deals with after acquired security interests like that. But do we have a financing statement? Do we have that's still current for your security agreement? Has the California judgment or the New York judgment been registered in California? I mean, do you have a security interest anymore in any of these property?
The answer to all those questions are yes, but those are factual. These are factual issues that the bankruptcy court never bothered to adjudicate because the bankruptcy court found it irrelevant. She found it irrelevant for a different reason. And I'm sorry, I can't read the names on the justice and the judge in the middle is saying it's irrelevant for a different reason. He's saying it's irrelevant because 362H only applies when the debtor schedules it as secured. And so you are asking a correct question is, do I have a legitimate security interest? But the issue here is that there's been no adjudication one way or the other because the bankruptcy court found that issue irrelevant. And it seems as if your court might also rule that it's irrelevant because the debtor didn't schedule it as secured. I believe it's highly relevant because your interpretation that then a debtor can dodge 362H simply by taking a secured property which is secured and just not listing it as secured, and they get a get out of jail free card, right? And that.
So, Mr. Kleidman, let me ask you a different question. If you have what the debtor is exempting is equity in the collateral, correct?
Yes.
If you have a $36 million judgment, and we're talking about $46,000 worth of personal property, and you are secured in all of the personal property, including the watch, then there is no equity under your analysis, right? So what? Well, there's no equity for the. Does it matter whether the bankruptcy court enters under those circumstances an order that says that he has the right to exempt the property when your security interest or your whatever it is that you claim it gives you the secured status is it well in excess by tenfold the value of the collateral?
Well, the thing is, you see, is that after this bankruptcy is over, regardless of how it plays out, if I can prove that I've got a security interest in this collateral.
It doesn't matter if he has an exemption, does it? If you can prove you have a $36 million interest in $46,000 worth of
the exemption matters big time because, I mean, an
exemption deals with the equity above the secured claim. I mean, if you have a secured claim against the iWatch or some of this other personal property, your lien, if you have one, and I don't think there's been any determination that you do have a valid lien, but if you did have a valid lien, doesn't that pass through the bankruptcy?
It does pass through the bankruptcy, but I'm hurt by the exemption.
No, you're not. A secured creditor, you take an example of a house, okay? Person has a $500,000 house and a $250,000 mortgage. And in California or in Washington State or other places, you could claim a $250,000 exemption. Okay, the debtor has a $250,000 exemption. They're going to be able to keep that. But when the bankruptcy is over, the secured creditor can still go after the house and collect their $250,000. The exemption is ahead. The secured claim is ahead of the exemption. If the house was secured by that $500,000 house was secured by a $600,000 mortgage. In other words, the property was underwater. The debtor's exemption there isn't anything to exempt. There's no value there.
Okay, then I thought that if, for example, that let's assume the Apple Watch is worth 10 grand and he gets a $3,000 exemption, and then I prove I have a security interest. I thought that he would get I could foreclose on the Apple Watch, the iWatch, but have to give him $3,000 back because of the exemption. You're saying I don't have to do that.
Well, it depends on whether your claim is secured by a security interest or your claim is secured by a judgment, because one might be avoidable and the other one would not be. And the example that Judge Corbett just gave you was one where you have a consensual lien. If you have a consensual lien, that is ahead of any exemption claim the debtor might make.
Yeah, if you have one. I don't think there's been a determination that you have a valid security interest.
Yeah, no, that's true. What you're saying is true, because it seems as if the bankruptcy court found that issue irrelevant, and it seems as if this court is also going to find it irrelevant based on the interpretation of 521A2. And maybe but I guess the thing is that I believe that the correct ruling here. I'm way over my time, so if you I believe the correct ruling here is that there's no grounds to exempt the property because 521A2 does not give a debtor a way to circumvent and get a free ride out of the statement of intention requirement simply by taking property which is in fact secured and just listing it as unsecured. But
the remedy for the secured creditor is stay relief. It's not to use 362H. It's to come in and say, I want stay relief. He didn't list it. I have a security interest. This is they're not paying me. Whatever, they're not doing what they're supposed to be doing. They're in default. I have the ability to get and go to state court to get the property. So it's not like there's a free ride just because 362H doesn't apply. What you're trying to do is use the code in a way to remove the property from the estate without having to file a stay relief motion, without having to get the court to analyze whether you actually have a secured claim. You're trying to use this in some way to manufacture a way for you to get the property out without having to prove your side of the case, I think.
No, that's not true. I'm not trying to circumvent my proof. I'm saying...
Well, rather than oppose the exemption claim, you could move for stay relief. Couldn't you? Shouldn't have you have done that?
But I suppose stay relief on the grounds that I have a secured interest.
Well, no, if you cause for relief from the stay under 362, if you have cause for relief from stay, and in a Chapter 7 case, there's no reorganization going on. So what you can get relief from stay if you can show that there's no equity in the property. If there's no equity in the property and it's not necessary for an effective reorganization, there is cause for relief from the stay.
Right. Well, in any event, I chose an alternative means of getting, the code provides for alternative remedies, and I chose to just have a declaration that the property's not there under 362.
But if you have a security interest, a consensual security interest in the property,
yes, it
doesn't matter whether the debtor's claimed this property as exempt or not, because if you have a security interest for the $5 million loan, or it certainly is worth more than the $40,000 worth of property that was claimed as exempt.
And if you don't have a security interest, if you don't have it, then she was right to deny it because you're just an unsecured creditor who's making a claim. So either way, it's irrelevant. And that's the problem that we're confronted here with, is what difference does it make? If you are correct, you have a security interest, it's valid, then your security interest exceeds the value of the collateral, and the exemption claim is irrelevant because you have a valid consensual lien. If you don't have any lien on the property, if you're not a secured creditor, then she was right to deny it because you don't have standing to object to the claim of exemption as an unsecured creditor You're not the one that's able to say that 362H applies or that 521A applies.
Right. Okay. Well, there's been no determination one way or the other in the bankruptcy court, at least, whether I have a secured interest. But in any event,
Well, thank you for your
I'm way
thank you
over.
for,
So
thank you for your time.
I'll expect the affirmance soon. Thank you very much, Your Honor. So.
Well,
Thank you.
Thank you. We'll issue a decision as quickly as we can.
All right. Thank you, Your Honor.
Thank you.
Thank you.
And with that, we're done. Thank you.